I've been receiving so many questions lately from parents within the community, and that question is, Peggy, what is child protection order? In fact, a few of them have actually received child protection order notification and they are confused what it is and what to do. But I just want to say, hey, don't panic. Don't panic, okay? Yes, this video is part of our bite-sized videos that we have been doing on child safeguarding, and the aim, like I say, is to educate ourselves to ensure that we prevent our kids from going into social care. Because believe you me or not, there are children that have been taken into social care which can be avoided. We just need to educate ourselves so that we know what to do and how to do it. So for anybody who doesn't know me, my name is Peggy Barre, and I am so glad that you are here with us today. So let us roll. What is child protection order? Okay, so child protection order is commonly known as CPO. It's a legal order that is issued by the family court when a child is in immediate risk of significant harm. And this order, it allows the social services or the police to take urgent action to protect the child, which may include removing that child from the home, right? If they suspect or they have evidence that that child is going through some sort of abuse, that order can actually give them the right to take that child off from that home. Okay, this type of order is commonly used in emergency situation where the child's safety is in danger due to abuse, neglect, or other serious concerns. Remember, I said in my other videos that removing your child from the home is the last resort, the very last resort. That means they would have tried all other options until that is the last resort before they can remove that child. Or if they notice or have evidence that that child is in immediate danger, then yes, they can remove that child, right? So like I said before, I have done other videos on important topics like understanding child in need plan, child protection plan, and how parents can work with social services to ensure that their children the child in need plan are met. And if this child in need plan is met from the initial stage, it can prevent that child from going into social care. Because remember, like I said, it starts from one angle, and if it's not dealt with appropriately, it keeps moving from next to the point where your child may be taken away from you. So there are 4 types of child protection orders. Okay, the first is called emergency protection order, EPO, and that is outlined in section 44 of the Children's Act 1989. So remember, the first is emergency protection order. I know some parents have had these ones, and it is this particular emergency protection order is used when a child is in immediate danger and needs urgent protection. And remember, like I said, they must have had evidence that that child is in immediate danger. So social services or the police can apply to the court for an EPO, and an EPO lasts up to 8 days, but it can be extended to 15 days. And again, this particular order allows authority to remove the child or to prevent someone from having contact. So you can see that as parents, because I know some of you parents have been saying, I've been stopped, from contacting my child, or their auntie and uncles have been stopped. So this is what can happen, right? So they can actually stop you, prevent you as a parent from contacting your own child. So yes, it happens, right? And it's within the law. Okay, so the next one is the interim care order, which is called the ICO, and that is in section is actually stated in section 38. 38 of the Children Act 1989. So this particular one is issued when social services believe that the child is at risk of harm and should be in temporary care. Okay, so remember I said in my previous video, if you haven't watched the previous video, please go and watch previous videos, because like I say, these are something that may happen and then we're not conscious of, and then it moves aggravate from one stage to another. So this particular order grants the local authority the parental responsibility, meaning that they can decide where the child lives. They can decide where the child lives. So for some parents that are saying that, how they have the power to do that, okay? And this particular one lasts until the final decision is made in care proceedings, and it's usually within 26 weeks, okay? The third type of court order is called the full care order, and that is in section 31 of the Children's Act 1989. And this care order, it gives social services a long-term responsibility for the child. It gives them long-term responsibility for the child. So the child may be placed in foster care with relatives, or it may be placed in residential care. So remember, like I say, they don't just take your child from you. They will explore other options where your child is safe. It can be safe with a relative. It can be safe with, foster carers and all of that. Okay, so it usually remains in place until the child turns 18, unless the decision is overturned. And of course, the fourth court order is called the supervision order, and that is in section 31 of the Children's Act 1989. So this is the order that many parents in the community have. They have the supervision order. So this one, the child remains at home, but social services monitor and support the family. Okay, and it usually lasts for up to 12 months, but it can be extended. And remember, like I say, this is where you as a parent need to work closely with the social services. You need to seek help. You need to follow their guidance, because they are there to help you to make sure that they prevent that child from going into care. So parents can retain their parental responsibility, but they must follow the court requirement. This is the order that most parents have, and like I say, they find it intrusive and disturbing why someone should be controlling how they parent their children. And as shown in my previous video, it is actually possible to avoid this by collaborating with the social services. Remember, like I say, it's a space of 12 months. That 12 months, the social service will always come, the social worker will always come, just to make sure they monitor how you're parenting your children, if everything is fine, if everything is okay, and they know that they are confident that your child is safe with you, then yes, in 12 months time, they can actually end the supervision order. So when can social services get a child protection order? That is another important question. So social services must actually provide evidence to the family court that the child is at risk of significant harm. They cannot just go to court and say, hey, we want to intervene in this family or take this child. No, they have to show an evidence. They have to have an evidence, and the evidence will be either physical abuse. That means they would have seen evidence of hitting, of severe punishment. They may have had evidence of emotional abuse, especially, for example, constant criticism, threats. Maybe you've been threatening the child, exposure to domestic violence, or also they might have had evidence of sexual abuse, e.g. exploitation, inappropriate touching, and all of that. And again, the big one, they might have had evidence of neglect as well. Neglect is a big one that sometimes can be ignored. It can be maybe lack of food, medical care, lack of hygiene, or lack of supervision. All of these things can actually be an evidence. And remember, sometimes they may not have it just in one go. They may have been tracking these things bit by bit, and then they start plotting at it, adding the graph together. 1 + 1 is 2, 2 + 2 is 3, 3 + 3. Okay, so yeah, so that is how it works. So that's why we have to be educated, so that we can be alert, about these things. Now, another important question that we need to ask is, can parents stop a child protection order? This one, you need to seek legal advice immediately, right? For example, if you have a child protection order and you know that you were not expecting it, and you think that maybe your child is fine, your child is safe, then yes, you can actually seek legal advice so that your solicitor can challenge the order in court. Again, you can provide evidence to show that your child is not at risk, e.g. you can provide evidence with a clean home, their medical records, support networks. All of those things are evidence that you can provide to prove that your child is safe at home. Again, you can attend court hearing. If you receive a court summon, it is crucial to attend and present your case. Don't ignore it. Go. If they say go and present your case to the court. And again, like I say, always say, work with social services. Demonstrating your willingness to improve the situation may help to prevent your removal. Okay. So I hope you learned something, and yeah, if you did, share with families and friends, because like I said, believe you me or not, people are going through a lot of these challenges, and some of them is just ignorantly, they don't know, they don't understand what they can do and how they can go about it. So thank you so much for watching, and I'm going to see you in the next video. See you. Bye bye.